Mr. Speaker, I commend it to the House. Thank you.
I call the Honourable Member Charles Chauvel.
Thank you, Mr. Speaker. Mr. Speaker, I've listened with great interest to the contributions in the debate from government members, and I've heard the professions of shock from Nikki Kay and others. They weren't terribly convincing, but well done, Nikki Kay, on the attempt. I want to say I'm shocked at the process abuse that we are seeing here yet again, with the Canterbury emergency being used as an excuse. This is, well, that's ironic coming from the Minister who was in contempt of court, but we'll leave that one for later on, shall we? I'm shocked that members opposite continue to try to wrap themselves in the flag, say, oh, Canterbury's in a terrible state and so we can do anything we like with process and it doesn't matter. I thought that the Minister's second reading contribution was actually quite commendable, and I know it's tempting to go off on a frolic for Maurice Williamson to make little jokes about the Oharu census. Ha ha, good on you. But actually this is really important, and I hope that we actually can have a sensible debate about it, because as the Minister said in his second reading contribution, there are concerns. What happens to the Māori option? We heard from Te Roroa Flavel that they've had some sort of assurance in the Māori Party from the Minister that the Māori option, the Māori electoral option, will remain intact, notwithstanding the deferral of the census by 2 years. I'd be very interested to hear from the Minister how that is, because just on my initial calculations, the maths actually starts to get quite difficult in terms of that 5-yearly option. Similarly, it would be useful to hear from the Minister about the effect of the deferral of the census on the population-based funding issues that he referred to. He said that his colleague, the Minister of Health, was concerned about this, because we all know that DHB funds are calculated on the basis of population movements. And if we are going to have a 7-year block now rather than a 5-year block, what is the effect of that on those sort of movements? What's the effect on the budget? What's the effect on the fiscal position? Now, these may or may not be major issues, but they are proof. The fact that they are raised in the debate, they were raised in the debate by the Minister, indicates the sense of following the standing orders, even for a brief period of time, and sending this legislation off to a select committee so these sort of technical questions can be addressed. This is our job. It's not some optional extra. It's what we're here to do, to scrutinise legislation, to make sure that we're getting it right, and to deal with these sort of issues. This is why the public pay members of Parliament what they pay us. And I'm shocked that members opposite can just brush these concerns aside as if they're minor procedural issues, all justified because there's been a Canterbury emergency and we don't need to actually think about the details. Members should just reflect on the fact that too often in this House we deal with legislation to amend and undo acts that we have passed in the relatively recent past. And I hope, for the sake of members opposite, because all these speeches are on the record, that we aren't going to be in a similar position on this legislation. Sir, I am disturbed, as I said earlier, about some of the legislation's language. I referred to the obviation of the proclamation language earlier, but there's also a very, very interesting justification advanced in the explanatory note for the deferral of the census. We have the reassuring statement on its face that this streamlined process relates only to the 2013 census, but then we have the quite alarming statement and is made in light of public announcements already issued on the next census. Well, just because it's settled law in this country that I hope every member knows, that just because a minister announces that a statutory requirement isn't going to be followed doesn't mean that that statutory requirement shouldn't be followed. And I'm a bit taken aback to see in I'm a bit taken aback to see in an explanatory note to a bill that one of the reasons for the bill is that a minister's already announced that it should be so publicly. That isn't how we make law in this country. It's still the role of this House to make laws, and I think all members should be a bit disturbed that has crept into the drafting here. The other point that it is worthwhile making, I think, sir, is that there is another part to this bill, and it hasn't received terribly much attention to date. I hope the Minister of Statistics feels that he's fully briefed and competent to have carriage of this part of the legislation through the House. He said he had speech notes from his colleague, the Attorney General, and I'm pleased about that because I think he's going to need to draw extensively on those in the committee stages. There is nothing, I repeat, in the proposal to allow an acting Chief Parliamentary Counsel to be appointed that disturbs the opposition. We voted for such a position when we agreed to report the legislation bill back to the House. But that bill's just languishing on the order paper. Why isn't it being brought forward for a proper debate and discussion? It would do a lot of good things to make our parliamentary procedures more effective. Instead, we have this provision plucked out of that bill and sought to be advanced under urgency. And the Minister hasn't addressed in any of his contributions why that is. How long can we have a Chief Parliamentary Counsel on an acting basis under this legislation? Is it proposed that it might be 6 months, 1 year, 18 months, 2 years, longer? There's no limit on the face of the provisions in the bill as to how long a person might act in the very important capacity of Chief Parliamentary Counsel. So we do need to hear, I think, from the Minister why it is that this particular provision is being advanced under urgency, and we need to be assured that it is not a provision that simply exists and is sought to be advanced because the Minister is seeking to benefit any particular individual. If the position were reversed and it were an attempt to act to the detriment of any individual for hidden reasons, then it would clearly be unconstitutional. The reverse position must therefore also apply, and Parliament is owed disclosure as to why it is that these provisions are seen to be so important on this occasion. So I do look forward to the remainder of the debate, including the committee stages, sir, because those matters, and in particular the last one to which I've adverted, is one that we will be continuing to seek answers on.
I call the honourable member